One wonders what are the fundamental rights are all about. Are they given to citizens or are they given to any other people? Are they absolute in nature or will there be any reasonable restriction on it? So here we bring a very interesting discussion for you, which is called features of fundamental rights in Indian Constitution. My dear friends, मैं आपके सामने एक मजेदार सा वीडियो और लेकर आया हूं. दिस इज ऑन इंडियन कॉन्स्टिट्यूशन. ठीक है, आई थॉट टू प्रिपेयर अ सॉर्ट ऑफ स्मॉल सीरीज ऑफ वीडियोस wherein I try to give you all detailed information about fundamental rights and in general about Indian Constitution. Here in this video, I'm going to discuss about features of Indian Constitution related to fundamental rights. ठीक है, I'm sure you are enjoying with ProTalent, so do not miss out to take this PDF from protalentdigital.com. Do not miss out to like this video and subscribe to our channel. Let me start to talk about fundamental rights. They are guaranteed by the Constitution and these are the features. I'm going to put one by one features in front of you and we are going to discuss about them. Okay. In case if you have any question or query, feel free to put that into comment section. I'll be more than happy to answer those. Okay, let me start to talk about number one. Some of the fundamental rights are given to citizens, while some of the fundamental rights are available to everyone. Yes, for example, article number 21. Article number 21, which is right to life. Similarly, article number 14 is given to everyone, that is, you can say equality before law and equal protection of law. So those, you can say, rights are given to everyone and there are few rights which are given to the citizens. So let me give you small work that will be good. So please list down those fundamental rights which are given only to the citizens and list down those rights which are given to everyone. Great. So that's a number one point. Number two, they are not absolute but they are qualified. That means state can impose reasonable restriction, but these reasonable restrictions are qualified by the court. Whether Supreme Court approves that such kind of restrictions are reasonable or not is very important. Yes, so fundamental rights are guaranteed by the Constitution. ठीक है, they are basically qualified, they are not absolute, there are some reasonable restriction comes, but who decides whether they are reasonable restrictions or not? It is decided by the courts in our country and courts are independent in our country. Thus the court strike a balance between rights of an individual and those of the society as a whole, between individual liberty and the social control, to control certain things. Okay, to give lot of benefits to large number of people, there are some reasonable restriction. So in the last discussion, I raised a case about Jammu and Kashmir. Here I bring that case one more time for bringing social control of Jammu and Kashmir area, that is individual liberty is controlled. Okay, so will that be termed as reasonable restriction or not is a big question. In my opinion, it is. Let us see what Supreme Court says in the long run. Coming to number 5, most of them are available against arbitrary action of the state. Remember, we are a democratic country. We do not want state to arbitrarily put any kind of control on us. ठीक है, हम चाहते हैं कि सरकार या जो भी सरकार की पोजीशन पे बैठा है वो अपनी मन मर्जी से हमारे ऊपर कोई रिस्ट्रिक्शन न लाद दे. ठीक है, और इसकी वजह से we want that हमारे fundamental rights are to be protected. Yes, some of them are negative in character. That is, they place limitation on the authority of the state, while certain other fundamental rights are positive in nature and they are giving certain privileges in the hands of people. For example, state shall not discriminate. ऐसा करके article number 15 और 16 चालू होता है. So that is negative in nature. It is placing limitation in the hands of state, while there are positive words which says the right to life. ठीक है, so these are the kind of differences available in our, you can say, fundamental rights. So this kind of features clearly provides in the mind of the, you can say, judges to provide a clarity whether they are properly justiciable or not. More importantly, they are justiciable. They are allowing people to move the court for their enforcement. ध्यान रखना, there are, you can say, certain cases for fundamental rights you can go to the court, and there are certain scenario where the fundamental rights are self-executory in nature. I will discuss about that issue in short time, but they are justiciable in the nature. While our fundamental duties, DPSPs, they are not justiciable. ठीक है, मतलब आप उसके लिए कोर्ट में नहीं जा सकते हो. इस केस के लिए आप कोर्ट में जा सकते हो, बिल्कुल जा सकते हैं. If they are violated, you can very well go to the court. Next features, that they are defended and guaranteed by Supreme Court. What is the ultimate objective of a Supreme Court? Primarily to uphold the Constitution, और Constitution का सबसे महत्वपूर्ण part is called your part 3 of fundamental right. Hence, the aggrieved person can directly go to the Supreme Court and not necessarily by way of appeal against the judgment of the High Courts. So there is no need to go to the lower court and then the High Court and then the Supreme Court. He can directly go to the Supreme Court. This is the objective of this particular part. They are directly defended by the Supreme Court and they are not sacrosanct or permanent in nature. That means उसको कोई छू नहीं सकता है, ऐसा नहीं है. ऐसा नहीं है कि वो परमानेंट है. ठीक है, पार्लियामेंट कैन curtail or repeal them, but there is only one process through that, that is called constitutional amendment and not by ordinary act. Okay, so ध्यान रखना, there are certain fundamental rights can be modified, can be changed, can be added, can be deleted, can be reduced. That is possible. That is possible. ध्यान रखना, because they are not permanent in nature, they are not sacrosanct in nature, but they have to be modified only through a process of the parliament, which is constitutional amendment. But at the same time, those fundamental rights, when they are changed, ठीक है, when they are changed, they should not change the basic structure of the constitution. ये एक मजेदार सा प्रिंसिपल सुप्रीम कोर्ट ने डिवाइस किया था इन वन ऑफ द वेरी फेमस केस कॉल्ड कृष्णानंद भारती केस. वहां पे ये बोला गया था दैट गवर्नमेंट or parliament would like to change anything, they can change, but the basic structure doctrine cannot be changed. That means constitution का basic structure cannot be changed. इंडिया की डेमोक्रेसी बदलनी नहीं चाहिए, ठीक है ना. इंडिया रिपब्लिक है, इंडिया डेमोक्रेटिक कंट्री है, इंडिया सेक्युलर है, इंडिया सोशल है, सोवरेन है. ये बदलाव नहीं आने चाहिए, फंडामेंटल राइट नहीं बदलने चाहिए. ऐसी बहुत सारी चीजें इसमें बोली गई थी. दे कैन बी सस्पेंडेड ड्यूरिंग ऑपरेशन ऑफ नेशनल इमरजेंसी. हम फंडामेंटल राइट्स को, दैट मीन स्टेट फंडामेंटल राइट को सस्पेंड कर सकता है, पर दोस्तों दो आर्टिकल्स है जो सस्पेंड नहीं हो सकते. दैट इज आर्टिकल नंबर 20 एंड आर्टिकल नंबर 21. I'm sure you are aware about that. Article number 20 and article number 21. You may ask, sir, what is article number 20? Article number 20 are basically a kind of protection given to the convict person or the person who is accused of an offense. ठीक है, no double jeopardy, no self incrimination and no ex post facto law. This is article number 20 and article number 21, right to life. Okay, so this cannot be suspended during emergency. Rest of the other articles can be suspended. ठीक है, further 6 rights which are guaranteed in article number 19 can be suspended only when the emergency is declared on the grounds of war or external aggression. ठीक है, that means only because of emergency scenario. We cannot suspend article number 19 in any other scenario except a scenario called war or some external aggression. That means during financial emergency, can we remove article number 19? No. During the presidential, you can say rule, can we remove? No. So there are 3 kind of emergency in India: article 352, article 356 and article number 360. Okay, 356 और 360 के दौरान article number 19 नहीं आप suspend कर सकते हैं. article number 20, 21 तो इस scenario में भी you can say आप suspend नहीं कर सकते हैं. In certain scenario, this fundamental rights will have a limited scope. For example, there are certain articles like article number 31A, article number 31B. So they are basically related to acquisition of estates. So primarily, let's say for the purpose of railway, for the purpose of army, we require to purchase or acquire certain kind of real estate, and for that purpose we have to give certain limitation to fundamental rights. So thereby article number 31A, 31B and 31C, वहां पे fundamental rights थोड़े से limited लगते हैं, and their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies, ठीक है, they are restricted or abrogated by parliament as per article number 33. That means they will be applied in a limited scenario to this group of people, okay, or for their work this is applicable to common people in a normal manner, okay. So I hope this is very clear for your understanding. Moving further, application can be restricted while martial law is in the force in any area. Now what is martial law? Martial law is a military rule which is imposed under abnormal scenario. It is very different from the imposition of national emergency. So for example, there are martial law applicable in certain scenario like APSPA, I'm sure you are aware about, Armed Forces Special Power Act, ठीक है. उन जगहों पे इस तरीके के जो फंडामेंटल राइट है उसकी एप्लीकेबिलिटी बहुत लिमिटेड हो जाएगी. मोस्ट ऑफ देम, that is most of the fundamental rights are directly enforceable. That means they are self executory in nature, so they are directly enforceable, while few of them can be enforced on the basis of a law made for giving them certain kind of effect. For example, such a law can be made only by the parliament and not by the state legislature, so that uniformity is there across the country. See, this is article number 35. So most of them are self-executory. So the big question could be, sir, can you tell me which are the self-executory, you can say, kind of rights? Yes, I'll explain you self-executory versus executory. Self-executory, which means we do not need a separate legislation to enforce such kind of rights, okay, and they are majorly covered of this part 3, ठीक है, and they are not only available against the state but they are also available against the individual, while some of them are non-self-executory. For example, article number 15(2), equality in regard to access to and use of places of public interest, okay, वहां पे कुछ लॉ बनाने पड़ते हैं, है ना, तो ताकि कोई भी बंदा कभी भी उसको एक्सेस करने की बात करे वो जरूरी नहीं है. बट इक्वालिटी, आर्टिकल नंबर 14, आर्टिकल नंबर 21, ठीक है, वो एक तरीके से सेल्फ एग्जीक्यूटरी है, उसको कोई तरीके के लॉ बनाने की आवश्यकता नहीं है. अब जैसे आर्टिकल नंबर 24 है जो नॉन सेल्फ एग्जीक्यूटरी है, हमें अलग से लॉ बनाने पड़ते हैं विच इज प्रोहिबिशन ऑफ द एम्प्लॉयमेंट ऑफ चिल्ड्रन इन हैजार्डस एम्प्लॉयमेंट एंड सो फोर्थ. Yes, so I hope you understood the idea of certain rights which are self-executory and there are certain rights which are not self-executory. So similarly, article number 21A, which is called right to education, ठीक है, that is also non-self-executory in nature. Great, ठीक है. So I hope you have learned it well with me, all the important features of fundamental right in this particular video. अगर आपको ये वीडियो पसंद आया है, प्लीज आप फटाफट इसको लाइक करिए, इस चैनल को सब्सक्राइब करिए, बेल आइकन दबा दीजिए, एंड मोर इंपॉर्टेंटली आप मुझे कमेंट सेक्शन में बता सकते हैं कि मैं और किन किन चीज़ों पे आपके लिए वीडियो बनाऊं. ओके, थैंक यू वेरी मच एंड ऑल द बेस्ट.